in our Valley office. So we made a lot of progress in terms of staffing our Valley office with the appropriate supervision, and we're really excited and looking forward to continuing the expansion of our staff in the Valley, and as well as the other parts of our department. And I'll just keep it brief and leave that, and I'm available to answer any questions.
Great, thank you. Mr. Bloomfield's happy that you're expanding in the Valley. Any questions for Mr. Bertoni? Okay, and for the record, we've been joined by Councilmember Harris Dawson. We will receive and file item number 1 without objection. Item number 2.
Item 2, Councilman, this is a report from the City Attorney. It's a draft ordinance relative to application fees, and also there's a City Planning Department report.
Thank you. Staff here to present on this item.
Good afternoon, Jason Kleen, Department of City Planning. Before you today is the enabling ordinance for the department's comprehensive fee study. Adoption of the fee study will eliminate about $5 million in general fund subsidies. Per the direction of this committee, the proposed ordinance would keep the non-applicant appeal fee at $89, which is the current appeal fee. It caps the increase to fees for design review board for single-family homes at 20%, and it maintains the general fund subsidy for historic preservation cases. Staff from the department as well as the city attorney's office are available if you have any questions.
Great, thank you. When we last heard this in committee, we were concerned about the proposed fee increases for minor director's determinations and also for appeals fees. And we agree, I think I agree with the policy intent behind maintaining a level of subsidy for minor cases, and especially for those single-family projects, especially since cost plays a major role on whether people will comply or choose to go around the system. We want to make it easy on single-family homeowners to engage and comply with design reviews and overlays, and so we limited that increase, I think, to 20%. With regard to the non-applicant appeals fee, we were concerned by the abrupt and dramatic increase being proposed by staff. A 15,000% increase is not a viable option. And as we all know, public engagement is a cornerstone to the planning process and something that is distinct to the land use review processes in the city of LA. And it really gets to the heart of ensuring quality of life standards at the neighborhood level. If we cannot allow people to participate because of costs. So I'm glad to see that no increase in the final ordinance before us, and look forward to when the item is discussed in budget and finance to look at the appeals fees and the other fees. So thank you very much for your work on this.
Thank you, sir.
Any other questions on this? Seeing none. Okay, we will, the action on this is to approve. I'm sorry, we have 3 speakers on this item. Do we have a multiple agenda? Anybody on the multiple agenda that signed up for this as well?
Yes, there may be a speaker or two.
Okay, well, let's do multiple agenda first, and then we'll go back and do the speaker specifically on this item. Where's the multiple agenda list? All these here? So these people signed up to speak on more than... Okay, so it's all these on the multiple agenda card? And then these four are not? Okay, how do we know that? Okay, it doesn't tell me that there. Okay. So we have 4 people on the multiple agenda cards. Josh Albrechtsen. Did I pronounce your last name correctly, sir? No, sorry about that.
Hi, my name's Dr. Josh Albrechtsen. I'm commenting on 2, 3, and your historical preservation nomination on Kings Road. The main comments I want to make on sections 2 and 3 is right now LA is one of the hardest places to actually build, and it takes a long time, and whenever you have delays, it causes significant problems. I'm in favor of you guys increasing the fees significantly whenever there's a significant amount of units in the building that's being appealed. There are some people out there who are professional appeals people. They appeal every single building out there, and some of them try to get money and benefits off of the developer from it. There's actually been some LA Times articles about that recently, and I feel that you should make the costs so that they can't just like shoot out $100 bills at every single project within Los Angeles and hope to get paid off. So I'm not sure what you just said you're going to do about it, but I strongly encourage you guys to increase the fees required for these frivolous appeals of these multi-unit housing developments. The second thing I want to comment on is the Kings Road Historic Cultural nomination. There are hundreds of these buildings in this neighborhood. There's nothing distinct about this building than any other building out there. And we are in a housing shortage, and we need more housing. This takes 3 units and makes it 9 units. These are the kinds of projects that we actually need to happen in Los Angeles if we are actually going to have people afford to live here. I urge you to reject the nomination and allow this project to proceed. Thank you.
Thank you. Can someone move that chair there, please, from the front? I can't see. And who's that on your T-shirt, sir? Okay. Colonel. Okay, thank you. Which one? There's like 3 actors now. The main one, the original. Leah Memzik.
Memzik, and I dropped off, submitted into comment my issue with number one. Number one, do I get more than 2 minutes for all 3?
What's the rule?
How many
2 minutes?
How much time do I have for 3
You have
items?
2 minutes.
For 3 items?
Yes.
First of all, I don't think that's fair. But moving right along, and then I'll just get to the main point. Per the California Constitution, Article 1, Section 3A, I instruct you to release the memo. The reason for this is that the state of California is running a criminal enterprise. And I have laid it out here. One example, you fraudulently tell people the wrong municipal codes. One example is here. If your city planner is here, I've tried to talk to him, but he refuses. Debbie Lawrence said that she knew about it, but refuses to change it. And I've brought it to your attention before. So here's the true municipal code. Here's the false municipal code. You can't do that. You can't even have a meeting if you're going to lie to everybody. Here's my passport that I'm an American citizen. Here's the California Constitution that says that I am allowed to have inalienable rights to protect my property, and you've denied that. And the people have the right to instruct their representatives, so I'm instructing you today. Here's my release, the memo. And here's a letter from Dianne Feinstein and Adam Schiff saying that I'm a Russian. I'm not a Russian. And that is why I had to bring you my passport and to put into public record, so nobody ever says that when I'm on Twitter at Leah in LA that I'm a Russian or a bot. There I am. I'm an American citizen born in Venice, California. And so real quick, just to make sure, Vince Bertoni puts the true and correct municipal code, and that you don't charge people for appealing the government. By the way, that's a constitutional right to address the government for redress of grievances, and that should be free.
Great. Thank you.
Thank you.
So I have a list of about 20 people here. Are we still on the multiple item list? No? Carol's on the multiple agenda item list? Okay. Carol Cetrone?
Hi, good afternoon. My name is Carol Cetrone. I wanted to speak on item number 3, the small lot amendment guideline amendments.
Did you sign up for more than one item? I'm sorry.
Sorry?
I'm sorry to interrupt you. Did you sign up for more than one item?
Oh, yes,
Yes,
number
you did.
3
Okay.
and number 5.
Okay, great. Thank you.
Yes. I believe that passing these amendments at this point is a dangerous move that gives city planning the power to change enforceable guidelines without any public input. This is an example of the city's efforts to take power away from communities and give it to unelected bureaucrats who are making design policy. We asked for 2 years for you to make the guidelines enforceable, which you have done, but you have watered down the guidelines to the point where they don't mean anything anymore. I think that this measure, I think you should vote no on this item. I think you should send it back to the drawing board and listen to your constituents this time around. As far as item number 5, the Kings Road Historic Cultural Monument, I just want you to keep in mind that this was unanimously voted on by the Cultural Heritage Commission. I think it's a very important historic building, and by destroying it, you're not only destroying a beautiful historic gem, but you will also destroy 3 perfectly intact rent-stabilized apartments and send 3 families out of their homes. Thank you.
Lucille Sanders.
Yes, Lucille Saunders, La Brea Willoughby Coalition. You have our letters on the items. I'm going to speak on number 2 and number 3. As far as the appeal fees increase, we do have the support of our consulperson, Koretz, and we ask you to look at the multiple neighborhood consuls' impact statements, not to increase the fee increases on as far as the original appeal, but we also ask if there is a DBS appeal to the DCP, then the appellant becomes the applicant, and that increases the fees. We ask you to look at that, and that the person will remain the applicant with the original fees. As far as number 3, and this is on the small lot subdivision. This is agendized under the guise of environmental clearance, and even the mention of the draft design review standards, which were last reviewed in August of 2016, is missing from today's agenda. To make a full evaluation of any changes or to attempt to move the ordinance forward with the missing design review standards is a travesty. Major issues and objections to the current I'm trying to talk too fast, and projects were on the ineffective, non-binding, arbitrary guidelines. These were to be developed into clear, mandated design review standards as a part of the revised ordinance, and that's what we ask. Thank you.
Okay, so we will note and file multiple agenda item. Wasn't on my list here on the agenda. It should have been placed there, but we'll go back to item number 2, and public speaker is George Abrams.
Section 19.01B1A of the proposed fee schedule prepared by the city attorney should be changed so that an appellant other than the applicant of a building and safety appeal is not assigned the standing of applicant of an appeal under this section. Such person should be charged the same $89 fee as person other than the applicant of a normal planning appeal. And that is really because it's unfair to take someone who is appealing a building and safety appeal and then turn them into the applicant, and basically it disenfranchises aggrieved parties of the ability to challenge unfair and illegal projects.
Daniel Wright, Jamie Hall.
Good afternoon, council members. Daniel Wright of the Law Office of Daniel Wright and various concerned community organizations. we readopt all of the points and evidence set forth in our letter dated August 15, 2016, particularly if any surprises appear at the Budget Committee's hearing on the same item. None of the various appeal fee proposals that staff has given you take into account the circumstance where in hillside areas a developer buys and tries to develop multiple houses on an unimproved paper street. Although environmentally analyzed as a single project, an appeal of the multi-house project requires a separate appeal and appeal fee for each house. Thus, an appeal of a 10-house project would be 10 times the appeal fee for a major project that's in one of the non-hillside areas. This hardly seems fair and needs further look. Also, the comments you've heard about the building and safety appeal, those details are in my letter, and you should clearly take a second look at that, because a judge has criticized your building and safety appeal process as fatally flawed. Thank you.
Thank you.
Good afternoon. My name is Jamie Hall. I'm a planning and land use attorney. I appear here regularly, but today I'm speaking on behalf of the Laurel Canyon Association. We are a neighborhood association that was founded in 1930, one of the very first in Los Angeles, and we've been very active in terms of environmental protection, and we have filed various appeals throughout the year and have created better projects. And I just want to highlight that fact that appeals often create better projects for the city. And it's important that we not create an obstacle to creating better projects for facilitating public input. And they also correct errors. Just last Friday, I filed an appeal where an endangered species was on the site, and the city made a mistake, and it wasn't even noted in the M&D. So we don't want to have a situation where errors can't be corrected. So thank you very much for being thoughtful about this.
Thank you. Any questions or comments from committee members? Mr. Englander?
Yeah, to staff. So while we're not actually dealing with what a lot of the comments were in terms of updated fees, and that's going to be coming back separately in terms of looking at what that could mean. Number one, what was the timing on those suggestions that we could look at, the various options? And then a second thing was somebody had brought to me the idea of perhaps looking at various options that we could explore being, and just again hypothetically, where you would have a different fee depending on your radius geographically to where you lived. So you'd have sort of standing, if you will, because a lot of these appeals are done by people that, I should restate that. Some of these appeals are done by folks with no geographical standing, if you will. And so we want to recognize that too, while also, I think, making sure we recognize most of the folks who just spoke here today about the idea of what the appeal process could bring in terms of better projects or making sure that people have that opportunity. So what are some of those options, and maybe not even spelling them out now, I won't put you on the spot, but when is it that we'll see a list of various options that we can explore and start having that discussion come back?
So in the fee ordinance before you, the fee remains at $89 for non-applicant appeal fees. There was a joint report that was issued by the Department of City Planning and the Office of the City Administrative Officer that laid out about 5 or 6 different options, including having a fixed dollar amount, looking at the radius of the appellant to the actual project site, and then having a sliding scale of fees based on where the applicant was located. So I believe that those will be considered as a separate item from this comprehensive fee study, and that item is pending with the Budget and Finance Committee.
And so that item's not going to come back here, it's going to stay in budget?
The item was heard in this committee. It has not been heard in budget, so it was just the list of options that were available.
Right, so it was heard, but without recommendation. It was heard as an initial discussion, and I think the outcome was to bring it back here again.
Correct, and that the report has not been heard by Budget and Finance yet, so it has not been referred back to this committee yet.
Okay, and so we're clear, as soon as they hear it, it'll come back to this committee for an actual recommendation to council.
Correct.
Okay, got it. Okay, thank you.
Okay, any other questions? Mr. Blumenfield?
Yeah, no, just to put a finer point on it, that was the report back at the last meeting we talked about, and I specifically asked for, which is, I think we even had set a number of days when that report back comes back.
Yes, sir. So the department and the CAO had responded back with a list of options and what the fiscal impacts for those options were. We did the oral presentation of the report in this committee, and then it was also jointly referred to the Budget and Finance Committee, and it has not been scheduled in that committee yet.
So that's its next stop, when we would actually look at that, those appeal fee options would be in the Budget Committee?
Yes, it would be heard, and then if they make a recommendation, then that recommendation will probably be referred back to the Policy Committee for further consideration.
Okay. And the next fee study, when does that commence?
We are beginning this spring, and we hope to have an updated fee study to you sometime in the fall or winter of this year.
Okay. Great. Thank you.
Mr. Englander?
One follow-up, since it was also sent to Budget and Finance. Since there was no recommendation out of this committee, we heard it. We could theoretically agendize it any time if, for whatever reason, no recommendation comes out of Budget and Finance as well.
Yes, sir.
Okay, thank you.
Okay, thank you. Okay, so approve the item before us. Any objections to that? Seeing none, so ordered. Thank you. Item number 3.
Item 3, Councilman, this is a city attorney prepare ordinance as it relates to the small lot issue.
Okay, the planning department here, give a brief overview, please.
Good afternoon. My name is Jenna Monterosa, City Planner with Planning. With me today is Senior City Planner Nick Hendricks. What we have before you today is a comprehensive amendment to the city's small lot ordinance. This was a ordinance that was initially initiated by a motion that was co-authored by CD 11 and 13. It was recommended approval by the City Planning Commission in August of 2016 and was last brought before you in January of last year. And so in between that time and now, it's been in the city attorney's office, and planning has also been working with other departments and offices to ensure that the sort of details of the proposed amendment are in line with the spirit and intent of how it was initially brought before the City Planning Commission. So we're very excited to bring it back before you today. Planning in a submittal that was sent in December of last year is proposing 2 minor changes, but before going into those changes, we want to just give a brief overview of the ordinance and the amendment to make sure that, it's been a year, so we want to make sure that we're all on the same page. So, first adopted in 2005, the small lot ordinance was one that created a new housing typology for the city of Los Angeles. What it resulted in was a sort of cross-hybrid typology, was a cross between detached townhomes and single-family home ownership. And in order to do that, what it did was create incentives for new development that reduce setbacks, reduce lot size requirements. But what it didn't do was modify existing zoning of sites, and so it didn't modify density requirements, it didn't increase height. It just allowed for more compact housing typology that would otherwise be permitted on site. And so as a result, it created new opportunities for fee simple homeownership throughout the city, and so you have opportunities for fee simple homeownership in areas that are more of an urban setting that typically you would only see multifamily development. Soon after it was adopted, relatively soon after it was adopted, we did see that there were some initial challenges that were soon created, and this is just because of the fact that it was a new housing typology, and so you have unique design challenges that required further guidance from the city. In addition, small lot subdivisions were often met with resistance from specific parts of the city where you have, say, an older housing development in an area that the community plan has zoned for more intense development. So, for example, you may have a lot where there's an existing single-family lot or a duplex, That's 2 stories. But the zoning underneath that allows for, say, 4 units built to a maximum height of 45 feet tall. So whereas you have a new development coming in, demolishing existing structures and building anew, it would appear that we're increasing density on a lot, we're increasing height, when really that's what was otherwise permitted. So small lots, soon after the ordinance was passed, we began to see more and more resistance from the community. We began to see more and more appeals, and that's why this amendment was sort of initiated. We wanted to be able to preserve existing housing stock and also be able to thoughtfully treat the way in which small lots are implemented throughout the city. So in an effort to treat design, you may have heard folks talking about the small lot design guidelines, which were, I think, last updated in 2014. Those guidelines were very helpful for planners, but they were a bit limiting in that we didn't have the tools, and we don't have the tools in place right now to truly implement those requirements as formal standards and conditions. So a project that may not be in a specific plan or subject to a design overlay or subject to site plan review, when we're just looking at a map, when we're looking at design, we're looking at things like site configuration, access, easements, etc., but we're not looking at the way in which height is treated, the way in which massing is treated, roofline variation, etc. So we have appeals filed because projects they're not meeting the design guidelines, but really planners and planning didn't have the tools in place to require that small lots adhere to all the specific guidelines. And so, with that, the proposed amendment is before you. There's a few things that the amendment is doing. The first of which is sort of reeling in some of those incentives that were originally brought forward in the ordinance. So what we're doing is increasing required setbacks. So we're falling, with regards to front yard setbacks of a subdivision, we're requiring that the underlying zone prevail. And so if you have a lot that's otherwise required a 15-foot front yard setback, that's what will be required of a small lot subdivision. What we're also doing is reducing permitted lot coverage. We are also prohibiting small lot subdivisions altogether from the R2 zone. So this is all done in an effort to increase compatibility of small lot subdivisions and their implementation throughout the city. The other thing that the ordinance is doing is creating a clear process for the preservation of existing dwelling units and bungalow courts, as commonly referred to. Because what has happened in the past, I know I as a project planner have dealt with this, where you have existing, say, 5 units on a site that when they were originally constructed allowed for 5 units, and subsequently zoning has modified the permitted density. So now if you demolish, you're only allowed to construct 3 units. So now the city has a net loss of 2 units, and perceivably a bigger size development that just has been problematic. And so what the ordinance is doing is creating a clear path to preserve these types of housing units and to ensure that these types of housing typologies are preserved and potentially added onto with additional small lots, but that we don't lose precious housing stock within the city. 2 other things that the amendment is doing is formally recognizing MAP standards that would be maintained under the authority of the advisory agency, and that's where we're looking at MAP design standards that are allowed by in the MAP Act. So that's where we're talking about site configuration, access, utilities, easements, potential dedication for parkland, etc., but nothing with regards to design aesthetic. And finally, what it's doing is creating a clear administrative clearance process that would allow for us to examine and look at design of small lot homes. And so projects that would come in to be processed through the department would also go through an administrative clearance to look at specific design standards, and so that we're able to stamp an exhibit to ensure that what's proposed initially is what's built, and so that there isn't any sort of bait and switch that happens and has happened in the past. So, like I mentioned, we're very excited to bring this before you. This is a unique amendment because it's one that was originally drafted by project planners. So, these are issues that we're addressing here are things that, as a practitioner, we know will improve the implementation of this ordinance, and we know that these small lot developments will just be better received. And what I can say is that in the last year, we've had our planning department's urban design studio work alongside with developers to see and get some feedback on the proposed amendment. And so for the most part, developers are amenable to the changes. You know, they aren't amenable to things right now that are a bit premature, where, say, they're requiring additional setbacks, because potentially that can result in a potential loss of a unit, and so they're not willingly doing that until this is adopted. But for the most part, these are things that we believe will improve small lot subdivisions, and actually, since this test implementation, the number of appeals has gone down drastically. So I believe last year there was a total of 7 appeals of small lots, where in the highlight of it, you have over 27 appeals in one calendar year. So it has resulted in an improved process for planning. There were 2 small changes that we're proposing at this time, one of which, and these were submitted to the council file for your review. The first change is we're amending the language with regards to the administrative clearance to require that any subsequent changes, say, for example, if somebody purchases a small lot home and they decide to do some massive remodel to their home, that they have to return for design review as well. The second is relative to the preservation of existing dwelling units and bungalow courts. When it was brought before your body in January, there was a proposed removal of a year benchmark that said anything built prior to 1950 could be converted. Absent of that year, it became very problematic that a developer could potentially construct a new unit, not as a small lot, but then come back and convert and circumvent some of our processes. So our suggestion is to reinstate a year benchmark there, so anything that's 45 years older could be converted to a small lot home and basically take advantage of that. Those are our 2 changes that we believe will improve the proposed amendment. And there was one other thing. I think Councilmember Price might have asked a question about guest parking and asked us to report back. Guest parking is something that would be under the authority of proposed MAP standards. And so what our proposal will be is that guest parking will be required of any small lot subdivision that proposes 8 or more units. I think in the past, small lot subdivisions are treated as with regards to parking, it's a single-family home essentially, and so the code requires that two parking spaces be required for each small lot home. Yes, parking is something that we've never officially addressed in any sort of standards, and so what the MAP standards will do is say that anything 8 or more units that proposes construction of 8 or more units will require 0.25 guest spaces per unit, and in the event that there's a fractional space, we would round down anything up to 0.5, which is consistent with our zoning code, and that's our intent here, is to make it consistent with our zoning code. So with all of that, I think that addresses everything in between the time it was last before you. Like I said, we're excited to be here, and we're happy to answer any questions.
Okay. Any questions? Mr. Englander?
A couple. First, acknowledgement. I know you guys have spent well over 2.5 years, I think, on this.
Yes.
It's been a significant amount of work and outreach to the public and others, and just looking through the council file and all the notes, definitely a lot of time has been spent on it, and so I want to recognize and thank you for that. What would be, I think, that if they wanted to get an exemption or an exception under the new rules and conditions, particularly as it pertains to either guest parking or the setbacks, what would be the variance process for that under the small lot?
Well, if we're looking at setbacks, and what the code is proposing is that it's the underlying zoning requirements for, say, for the front yard. So if somebody wanted to deviate from that, they would still need to go through our Office of Zoning Administration, so by way of a zoning administrator's adjustment for reduced yards. And that would have a potential opportunity for, appeal and
Sure.
if there's any concerns from the neighbors.
Okay, and then I think you'd mentioned that there's one zone that they would not be allowed in. Was that R2? You said?
R2, yes.
Okay, what was the reasoning behind that? Just curious.
Well, I think the reasoning behind that is that R2, the built environment of a R2 zoned neighborhood is still very reminiscent of a single family neighborhood. And so the intent there is to keep it in areas that are zoned for truly multifamily potentially apartment buildings, essentially. And it's one strong concern that we receive throughout outreach and implementation of these. And quite frankly, we don't see too many because you're still required to have a minimum lot area of 2,000 per unit. So we didn't see it very much anyways, but it's a concern that was raised, and we thought it was easily addressed by just outright prohibiting it.
Was there any discussion on adding more density or reducing, instead of expanding, setbacks for around transit areas? Transit hubs?
That's a good question. I think...
Because that conversation really wasn't taking place a couple years ago, when, not to the
Correct.
extent it is today.
Correct.
When this was initiated.
Correct. Well, what I would say is that we've had at least one or two projects that did take advantage of our density bonus ordinance, and so we looked collectively at the site as with regards to density and how many units could be calculated with that. And so, I had a project, for example, that set aside, I think, 1 or 2 units for very low income, and they were able to increase their height a little bit. So I could see there being a potential opportunity, but I think we'd have to look at it a little more closely.
Okay, and then, I don't want to hold this up, but yeah, if there's recommendations we can add to it later, that
Sure.
might make sense. On the, you'd mentioned last year there were 7 appeals, which was significantly reduced, about a third of the previous year from 22 or so. What wasn't mentioned were how many were actually filed. So did we have like a percentage? Do you know? 7 appeals versus 22 is significant, unless there were only, if there were 10 applications last year versus 50 the year before.
Well, I would say, small lot subdivision is really in between, I think the time, I don't know about the current numbers, but I would say we calculated between 2005 and 2015 or 16. I think at that time, small lot subdivisions were about 9% of total maps that we processed in our department. But given that number, it was still pretty high. So I would say the highlight of that was in 2014, we had 23, and it's totally gone down. It's gone to 17 appeals, 12, and finally 7.
But how many applications are we getting for small lot in those years?
I would say, so last year we received about 50, a little over 50 applications. So anywhere from 30 to 50 applications we received.
And about the same amount the previous years?
Correct.
Okay. So yeah, that's a major reduction.
I think initially when the ordinance was first adopted, we didn't see very many, so you didn't really see any appeals. People were still trying to figure out how this sort of worked.
Sure.
The peak of it really came in 2013, 14, and 15, and that's where you started to see 30, 40, 50 applications per year.
Right. So, and it sounds like this will be a better streamlined process on the back end as well.
Correct.
Yeah.
Correct.
Okay. Excellent. Thank you very much.
Thank you. Any other questions?
Sure.
No. Mr. Blumenfield?
Thank you. When you're speaking of the new yard and setback requirements, you refer to the underlying zone and the adjacent zone. Can you clarify when and how those standards will be applied? Would give a couple examples?
Sure. So, for example, if you have a project that has, say, it's zoned R3 and it's surrounded by similar zoning, R3 or RD 1.5, you would have a front yard setback that requires 15 feet generally. And when we talk about setbacks for small lots, we're talking about the entire perimeter of the subdivision. It doesn't include, say, internal lot lines. So anything that's really visible from the street. So you would have, say, a 15-foot front yard setback. You would have a 5-foot side yard setback, and you'd have a 10-foot rear yard setback. Under the that's the proposed change under the amendment. What the amendment also says is that where you have a lot line that abuts a single-family zone, it doesn't happen very often, but there are parts of the city where, for example, you have maybe R3 or RD 1.5, and in the rear you have R1. In those instances, we would say that your rear yard is now 15 feet to create a better buffer between the R1. And the amendment is saying that if any of your lot lines abutting that R1 or more restrictive zone, that we're also reducing your side yard to the zone, to the underlying zone. So what that means is, say if you have a structure that's 3 stories or 4 stories, let's go with 4 stories. Whereas you would normally have a 5-yard setback, you now have a 7-yard side setback, and you have a 15-foot rear yard setback and a 15-foot front yard setback. So it sort of, it creates a better buffer between what we perceive to be more sensitive uses.
You're just defaulting to the more restrictive.
Correct.
Whatever the most restrictive zone that touches it.
Correct. Correct.
Okay. Great. Thank you.
Thank you. Any other questions? Okay, we'll go to public comment. Doug Haynes and Denise Brown.
Good afternoon and happy 2018. My name is Doug Haynes. I'm with the East Hollywood Neighborhood Council. The Small Lot Subdivision Ordinance has devastated the cohesion of historic neighborhoods throughout CD13, where staff reported that 26% of all such projects were approved. That's why the East Hollywood Neighborhood Council voted unanimously to request that revisions to the ordinance include transitional height requirements, that all underlying yard setbacks be followed, that the design guidelines be mandatory, and that conformity with street contacts be required. That would be consistent with many specific plans, and it's certainly possible. Unfortunately, almost none of that has been incorporated into the proposed regulations. After years of input, the ordinance remains an incentive to destroy communities with out-of-scale, inappropriate development. If the goal is to preserve historic bungalow courts, then the solution is to establish a citywide preservation ordinance to protect them, and that's something that needs to be considered. Thank you.
Hello, my name is Denise Brown. I'm speaking from my heart. Every day I leave my house and I see homeless people all around me. I get on the bus, they're sleeping on the bus. I get on the train, they're sleeping on the train. I don't think that we should let someone whose idea of fun is to denigrate other people maintain a residence that is heralded as special in a city like ours, which is so great and wonderful. I just don't think it's right.
Thank you. Any other questions or comments? All right, I also want to thank Councilmember O'Farrell's office for his leadership on making some recommendations on this item as well. I know they've been taking a very active role in this. So we'll move to include planning's amendments and approve the city attorney prepared ordinance. Any objections to that? Seeing none, so ordered. Thank you. Next item, 5.5.
Item 5, Councilman, this is a Cultural Heritage Commission report relative to the inclusion of the Atlan Reese Apartments as a historic cultural monument.
Good afternoon, council members. Ken Bernstein with Department of City Planning and Office of Historic Resources. This is a historic cultural monument application for the Atlan Reese residence at 106 through 108 and a half South Kings Road. This is a 3-unit, 2-story, streamlined, modern-style apartment building constructed in 1936 on Kings Road by engineer Joseph J. Reese for Samuel Atlan, who was a local developer and contractor as part of the Beverly Square residential development tract. While the Office of Historic Resources staff had recommended that the nomination be declined, the Cultural Heritage Commission voted 3-1 to support the historic cultural monument application, finding that the nomination met one of the historic cultural monument criteria for its association with a historic personage, its association with Rudolph Ising, who lived from 1903 to 1992, an animator who made significant contributions to the animated film industry in Hollywood. He was the co-founder of Looney Tunes, starting in 1930, and Merry Melodies, cartoons, 1931. Mr. Ising moved into the subject property in 1936 and resided there until approximately 1939.
Okay. That concludes your report?
That concludes our report.
Okay, and I see that, I just want to clarify in terms of the procedural process, how we got here. The original recommendation was to not include this item on the list of historic cultural monuments by staff, correct? That's what
Correct, right. The staff recommendation was to decline.
And then at the Cultural Heritage Commission, they did not take that recommendation, and they voted to include it. Now, what was the reasoning?
There was considerable testimony at the commission meeting about the significance of Mr. Ising to the history of animation and the film industry in Hollywood, and the commission did find that it met that single historic cultural monument criteria, that Mr. Ising was a historic personage and that this site was sufficiently associated with Mr. Ising and his contributions. The commission, I should note, also requested that the name of the proposed monument be changed. It was originally submitted as Adlin Reese Apartments, and the commission requested that the monument, should it go forward to approval by City Council, be changed to the Adlin Reese Apartments / Rudolph Ising Residence, based on the finding of its association with this historic personage.
Okay, and was this property identified in Survey LA?
It was not. Survey LA did not find the property eligible for designation.
Okay, in Survey LA, they did their initial surveys in this, and they had completed the report.
Survey LA did survey this neighborhood, but did not identify this property as individually eligible for historic cultural monument status.
Okay, and we see a number of reasons why something gets nominated. It could be a combination of several factors, and this one, the main one, is the fact that that a person of historical significance resided at the location, correct?
Correct.
How long did this person reside there?
Just under 4 years, from 1936 to 1939.
Okay, thank you. Any other questions before we go on, Mr. Blumenfield?
Yeah, thank you. I'm come to this with a lot of skepticism. He lived there 4 years of 79 years, tiny percentage of his life. And generally speaking, personally, it's one thing when the building is historic for a historic reason and that the architecture is something that is unique. But in this case, there's no claims of uniqueness on the architecture. We're simply looking at the fact that somebody of somewhat historic significance lived there for a tiny percentage of his life. The logical extension, every place that this person lived needs to be historic. There are very few people on this planet that I would give that kind of deference to, personally. So, and I'll say, is this the place he lived the longest in his life, of 79 years?
No.
So this is a place he lived for a short period of time in his life. And there's nothing besides the fact that he just resided there. Did he do anything special there?
Well, I'll let, I'm happy to let those who are speaking in favor of the nomination speak to that in greater detail. I will mention, of course, we are representing the Cultural Heritage Commission finding. The Cultural Heritage Commission did vote 3-1 to find that Mr. Ising was a significant historic personage for his contributions as an animator, and that association was significant with its association with this place. Again, our staff recommendation was to the contrary, that we had not initially found that association to be strong enough.
And as far as historic personage, what's the bar on that?
So in past nominations, and we developed some more detailed criteria on this through our work on Survey LA, our citywide historic resources survey, to really define what is a historic personage, what is the important historic association. And typically it would be someone who is considered a significant historic figure, someone who made very significant contributions to their field. And in finding an association between a historic personage and a particular site being considered for historic cultural monument status, we are typically looking at whether that historic contribution could be tied to this place and whether that contribution reflected the productive period of their career. So we're looking at not just someone who lived at a site for a short period of time, but whether it can be tied to the finding of why they're considered significant in the first place and the productive period of whatever endeavor they might be associated with. So those are the types of considerations we're looking at in finding whether or not the criteria are met related to historic personage.
And I guess I would hope, well, that maybe it's not in there, that would go a step further and that there be a tie not just to the time period that person was there, but a tie to that structure somehow, just because the person occupied that space during a time period, to me, doesn't cut it. So anyway, that's where I'm at on this. But
Thank you. Okay. We still, okay. Mr. Englander?
Yeah, no, just to back you up on this, Bob, I think the commission's recommendation to support this was Looney Tunes, if you will. If I could steal one from that. Yeah, I read the same thing and came to the same finding that it's 3 years that he lived there. And I've looked at all the pictures, I read all the staff recommendations. I would be inclined to go along with the original staff recommendation on this, too. Thank you.
Any other questions, comments before we go to public comment? Okay. Stephen Luffman, again. Mr. Luffman, you have 5 minutes.
Thank you, council members. I am the applicant of this historic cultural monument that was deemed worthy by the Cultural Heritage Commission to bring forward to you. It is supported by the Los Angeles Conservancy, the Animation Guild, the Art Deco Society, Hollywood Heritage, Beverly Wilshire Homes Association, and as of this morning, 380 individuals, including animators, historians, writers, neighbors, and housing advocates. The Adlin Reese Apartments, Rudolph Ising residence, honors animation great and cartoon pioneer Rudolph Ising. Rudy Ising was the first winner of an Academy Award for animation other than Walt Disney. He got his start with Disney in 1921. He lived at 106 Kings Road from 1936 to 1940. This was one of the most productive periods of his career. At the nominated building, he produced 2 of his 6 Academy Award-nominated films, including his Oscar-winning film, The Milky Way, which he also directed, and the first Tom and Jerry cartoon. In 1937, while living on Kings Road, Rudy Ising loaned his inkers and painters so Walt Disney could complete Snow White. Without this help, Disney said he would have gone bankrupt. In 1938, Ising produced Mirror Babies, the first Disney cartoon by an outside studio, while he was living on Kings Road. By any measure, Rudolph Ising is a historic personage. Jerry Beck, historian and author of 11 books on animation, told me, just show him the opening of Puss Gets a Boot. The Tom and Jerry cartoon is one of the most important, significant animated shorts ever. The only name you see on it is Rudolph Ising, and it was produced while he lived at Kings Road. Today, 106 Kings Road's rent-controlled apartments are home to the working people who keep the entertainment industry located in our city. Yet, in spite of the worthiness of this nomination, I see my work cut out for me. I'm sure you're all familiar with the developer's representation. While I am a volunteer doing this for the love of my neighborhood, our city, and our history, to save the homes of people who will be pushed out of this neighborhood and in return push people out of their homes in your districts. Councilmember Koretz has recused himself from support because he lives 2 doors away. His office did support the designation before he was told to recuse. The developer's legal counsel point out that the Office of Historic Resources recommended against the HCM. Yet the Cultural Heritage Commission decided that the building meets the criteria for its association with Ising. The HCM ordinance says the OHR serves the CHC, not the other way around. The developer says that the Bosco cartoon character is a stereotypically racist character. I agree. The Bosco cartoons are a product of their time and era. Racist characters and stories were prevalent at the time. Googling racist cartoons reveals a long list of offending titles, starting with those by Walt Disney. Yet in November of 2016, the City Council voted unanimously to make the Charlotte and Robert Disney House an HCM for its association with Walt Disney, a property he lived in for 2 months. Rudolph Ising contributed much more to animation than Bosco. He, along with his partner Hugh Harmon of iWorks and, of course, Walt Disney were responsible for the animation industry locating in the city. Rudy established the animations departments of Warner Brothers, MGM, Looney Tunes, and Merry Melodies, and people who work for him, like Hanna-Barbera, established their own studios here. The developer claims we are submitting this application to block much-needed housing. This assertion has nothing to do with the worthiness of the application. But if they would like to talk about housing, the project that this Weissman residential-related company proposes a 9-unit, 100% luxury building. The apartments will rent for over $4,000, as they do in their apartments across the street. The new building will eliminate 3 units of RSO housing. From 2006, Weissman-related companies like this one have destroyed over 300 rent-stabilized units. They are one of the leading abusers of the Ellis Act in law. Can I just finish? I have 2 more sentences.
Sure, go ahead.
Thank you. They are one of the leading abusers of the Ellis Act, a law enacted for ma and pa landlords to retire. In May of 2017, Curbed LA named Weissman as one of the 10 worst landlords for this reason. Nevertheless, an HCM has to stand on its own merits and meet established criteria. Clearly, this does. Thank you for your consideration of this worthy monument. Rudolph Ising should be celebrated. He brought a whole industry to the city. Please endorse this historic cultural monument. Thank you. And can I answer one more thing?
Thank you. No, so your time is up, and we let you go
thank you.
over. Thank you. We're trying to be fair to everyone here. Okay, the property owner is Rimini LP. I guess that's is that a representative? Limited partnership. Welcome.
Council members, my name is Daniel Friedman.
Before you go on, are you the representative of record on the documents as well?
I am, yes.
Okay, thank you. Go ahead. Yeah.
Council members, good afternoon. Thank you for giving me this opportunity to speak. Let me clarify a couple things before I get into the substance of this, and there'll be a lot of speakers who get into the substance as well. But first off, my client proposes 9 units of rent-stabilized housing, and almost all of their projects are rent-stabilized, so it's kind of a misnomer. I don't know where this is coming from. In terms of the substance of the nomination, here we have a 3-unit building, not identified in Survey LA, not within a historic district. Staff recommended against the original nomination. Staff recommended against the subsequent nomination after they looked at the site. And importantly, they also recommended against after Ising came into the picture. Remember, this application wasn't submitted as a property associated with a historic person. It was submitted for its architectural integrity. And then later in the game, they swapped it. They said, oh, well, they're not going to buy the architectural, so let's see if we can find someone historic. They find Ising, and suddenly at the next hearing, it's all about Rudolph Ising. But the reality is this isn't about Ising, and I think it's really unfortunate that this gentleman is being dragged into this. At the end of the day, I think this really comes down to the criteria. Because the association of this property to Ising, to the best that I've seen from the record, and obviously I have some role in understanding what's in that record, is 2 phone book entries. Now, the National Register Bulletin is kind of like the federal government prepares this document that explains how to apply these HCM criteria. And it specifically has examples, and I provided some in the packet that's in front of you, of what type of properties are acceptable as HCMs and which properties are not. And there's a great example just like this, where there's a case where the researchers found a property may have been owned by someone. Probably owned. Court records show this person, this historic person, owned this property. And the National Register Bulletin said, that's not enough. You need to show more. So that's not acceptable under the federal National Register of Architectural Standards. I also want to note that staff, I think, got it right, and I got to give them credit. They also found that he wasn't necessarily a historic person. So their staff report said, we don't know if Ising's a historic person, and with all due respect, I don't know if we can be comparing Rudolph Ising with Walt Disney. I think those are kind of different people in our city's history. And they also said this property wasn't associated with Ising, and I think staff was right. Finally, just to lay into this a little bit more, We had a third-party expert, obviously, who's very familiar with these types of standards, also looked at it, recommended against the nomination. The property owner opposes. Housing advocates, Abundant Housing came out. They submitted letters. They oppose. Finally, I want to make a point about procedure. We've had an ongoing issue, at least in terms of the few times that I've been in front of the Cultural Heritage Commission, about when they process applications. So I understand Cultural Heritage, the Office of Historic Resources is substantially overworked, and they don't have enough resources, and hopefully one day we can, resolve that. But the issue has been that people file nominations, and then they kind of sit around for a little while, and then get processed. And the Cultural Heritage Ordinance has a 30-day deadline. So a nomination filed has to be heard within 30 days. I'm not going to press this point because I think ultimately this nomination should be denied on the merits. But there is also a timeline issue that I submitted a letter into the record documenting our concern on. At the end of the day, I think I just ask that this committee look at the criteria and apply them. I was here not too long ago when the Bob Hope residence came up before you guys. Bob Hope's house, he lived at this residence for most of his life. He built it, he picked it. When I go to someone on the street and I say, do you know who Bob Hope is? They say yes. He's an important contributor to the city. And we voted down his house. And now we have Rudolph Ising. Most of the people that I speak with don't know who Rudolph Ising is, and for better or for worse, it just is what it is. And I would just ask that we apply the criteria fairly, reasonably, because at the end of the day, my client wants to provide housing for the city. We are in a housing crisis. And I think for the benefit of everyone, these HCM criteria should be applied evenly and fairly. So thank you so much for your time, and any questions would be
Let me a question. Now, what's before us is the nomination of the building to the historic monument status for the city of LA. What's not before us is a project for which is being applied. I'm not familiar with it, but there were some issues raised that there were some RSO units there for the other project. If those people are being displaced, are they being provided relocation fees?
One thing for sure is that my client complies with all the LS Act requirements, absolutely, yes.
Okay, because one thing we found, and we put in some motions to correct it, is that oftentimes we get reports here in the planning committee, and it may or may not involve RSO units, and I think the intent of this council, majority of us, I think if not all of us, want to protect RSO units, and we sometimes don't know when we're displacing individuals and if they're being provided the full benefits of the law and protections of the law. So we just want to make sure that I'm just bringing this up because if it's grave concern in the city at this time, that all attention is paid to those RSO units in that project, although that's not what's before us today. Today it's just the nomination of the project. So thank you very much.
Absolutely.
Thank you.
Thank you, Councilman.
Now we'll go to the remaining people on the public comment list. Each person has 1 minute. Rosalie Newell, Marjorie Ballantyne, Keith Nakata.
My name is Rosalie Newell, and I support the nomination of the Adlin Reese Apartments, former home of animation pioneer Rudolph Ising, as a historic cultural monument. I'm the owner of an apartment building on the 100 North block of Sweetser, which is 3 blocks from the Kings Road apartment, and I've lived there since 1987. My neighbors and I love this very walkable neighborhood and have come to admire the uniqueness of the Adlin Reese Apartments. We mourn the loss of so many beautiful buildings, and we want the destruction to stop. The developers don't live in our community. They have no idea how important our neighborhood is to us. They are absentees. Can't we save a beautiful building, a handsome building, on a still pristine side of the 100 South block of Kings Road, and especially since it deserves a historic marker as the residence of a great pioneer in the history of animation.
Thank you.
I support this monument. This building is where I make my home. I'm 70 years old, and I will be displaced from my neighborhood, a neighborhood that I love and that I've lived in for almost 14 years. Neighborhoods are also a part of history, and it seems that that is going to be left in history because our present doesn't respect any part of that. If they were going to build affordable housing, I might have a more difficult time arguing this, but I know that they're not. I already live in affordable housing, my home. And along with the fact that Rudolph Ising did live there and that it is a streamlined, modern architecture, I hope that I am not displaced at this point in my life. I'm a senior. My golden retriever is a senior. And I hope you help us out. Thank you.
Thank you. Keith Nakata, David Friedman, Karen Smalley.
Good afternoon, Keith Nakata. I'm here today in support of the designation of 106 Kings Road as a historic cultural monument. Despite of what you may have heard from the property owner, that does not negate the historical significance and contributions of Mr. Ising, as found by the Cultural Heritage Commission. The Cultural Heritage Commission is the city's dedicated body of preservation experts. Historic preservation has grown beyond the spotlighting of a building solely as an architectural gem on a pedestal, but as a broader preservation for the people and their stories reflecting the history of Los Angeles. This nomination reflects the history of a famous animator and the larger history of the film industry and now the tourism industry here in Los Angeles. There have been some specious comments by the owner regarding issues related to how the new project will provide more housing. But this owner, again, has been declared one of the 10 worst landlords and is currently allowing one of the units in this RSO building to be used as short-term housing. So please support the designation. Thank you.
Thank you. Next speaker, please.
Hi, my name is Dave Friedman. I do, in fact, own apartments. I do support things like that. But I just have a very simple question for any of you. Have you ever been to Irvine? Think about how soulless and ridiculous Irvine is, especially coming from a position that you are in. Very simple. Please look on Google Street View at this apartment building and then look across the street and see what they built there and ask yourself, is this Los Angeles or is this Irvine? Because all they're doing is taking the soul out of the neighborhood. Thank you.
Thank you. Karen Smalley, Marcelo Vavala, Mandy Sherman.
Good afternoon, council members. My name is Karen Smalley. I was a resident of this neighborhood for 18 years. I walked by this building nearly every day until I couldn't bear to walk down that street anymore because of what was happening. But that's not what this is about. This is about the historical cultural nomination of this property. I helped with the research on this. It was fascinating to discover the details of Rudolph Ising and his time in this building, as well as his wife while he was there, who actually was in the newspapers more even than he was at the time. But let's not forget, he won an Academy Award for work that he did while there, both producing and directing his film, The Milky Way. You cannot say that this was not a critical period in his life. He received 2 nominations while he lived there. He produced his greatest work. After he moved, he joined the Army to do work for our country and never went back to the height of animation that he was in before. So you cannot say that this was not the critical period in his life. Thank you for supporting the nomination.
Thank you. Next speaker, please.
Good afternoon, council members. Marcello Vavala, Preservation Associate with the Los Angeles Conservancy. The Conservancy strongly supports this HCM nomination. The Cultural Heritage Commission, the city's dedicated body of historic preservation experts, has spoken on this issue, specifically finding the property significant under Criterion 2 for its association with the animator Rudolph Ising for his contributions to animation in Hollywood. Likewise, and accordingly, the Conservancy urges this commission to recommend designation of this culturally significant property. Thank you.
Thank you. Mandy Sherman, Amy Gallaudet, Ben Cohen, Michael Kohanzad.
Mandy Sherman. As a third-generation Los Angelino, I feel I have the right to want to preserve history here. The streamlined modern building undeniably stands out as one walks or drives through the neighborhood. Rudy Ising was a big pioneer and influence in early animation when he lived here. The Cultural Heritage Commission and many others believe so. Please stop this building from disappearing from the architectural history of our wonderful community and place of luxury housing. The look of this neighborhood is so special. I can attest to the beautiful details here, as I live in Rudy's very apartment and will be displaced by the proposed luxury, non-RSO, non-affordable condo conversion. They want to add 6 more units that does nothing for affordable housing, all while tearing down history. Thank you.
Thank you.
My name is Amy Gallaudet. As an owner of residential real estate, I belong to 4 homeowner associations. Unanimously, we support Rudolph Ising Monument. This building will never be replicated, the destruction of yet another irreplaceable property. As an artist, I am heartsick. Wiseman Residential, the biggest destroyer of rent-controlled historic property, using the Ellis Act. They do not build affordable housing. A city is akin to a beehive. So where are the workers to live? Certainly not in LA, where they work. You can't have a city for only the rich and the famous. Where are their servants to live? Thank you for listening.
Thank you very much.
Benjamin Cohen, I'm against the designation. It's an absolute travesty how the city is handling our housing shortage. Everyone knows it's due to a supply and demand issue. It's basic economics. That's why our mayor called for 100,000 new housing. But instead of the city pushing for more housing, it seems like they're encouraging anti-development groups who are just abusing the system and trying to designate every project as historical. Not because they're historical, but they want to stop new housing. This King's Row nomination is the biggest joke of them all. Designating a building just because a racist animator possibly lived there for 4 years. If you designate this building, where does it stop? This is your time to prove to everyone that you are more concerned about what is best for the city and not about votes. Because it's not the developers who will be hurt if the projects are stopped. Trust me, developers will be just fine. But the city would be badly affected with less jobs, taxes, permit fees, and much needed housing. Thank you.
Thank you. Michael Henry Van Moyland, Leah Abbott.
Hello, my name is Michael Cohenzad. I'm here on behalf of the ownership group of 106 South Kings. Before purchasing the property, we did 2 things. We looked on Survey LA, and we hired an independent historian expert. 106 Kings is not listed on Survey LA, even though this area was surveyed. And our historian found no significance of this property. There is a tremendous need for housing in the city. If the city designates old buildings without historical significance as monuments, this will stop redevelopment and reduce the new stock of housing that the city desperately needs. The housing that will be replaced here will also be subject to RSO as well. I want to thank all those who are going to speak on behalf of the ownership group and in opposition of this frivolous application, and also voice my opposition to designate 106 Kings.
Good afternoon. Henry Van Moyland, Miracle Mile Forward. Preservation is not a game. It requires selectivity. Mountains of trivia do not make an HCM. An application like this damages the reputation of the HCM program. 106 Kings Road is a mediocrity, not designed by an architect, didn't even make it to Survey LA, which is a low enough bar. Mr. Ising may have lived with this building for 4 years. If it's designated, we have to live with it for eternity, and it is extremely ugly. I want to commend OHR for its considered report, which effectively destroys this application. And the question that really arises from this is, what is the point of a Cultural Heritage Commission that waves through DREC like this? Thank you very much.
Leah Appett, not here. Sylvie Shane, Deborah Gibbs, Nicole Moran.
Sylvie Shane, good afternoon. I've participated in many historic cultural heritage designations, and one of the most clear messages that was stated at a Cultural Heritage Commission meeting was that this is not a beauty contest. We often think that it has to be a beautiful building. That's not the case. Now, this one wasn't found to be worthy of architectural significance, but it was so enough to be featured as the cover of the Beverly Square subdivision ads by the developer himself. So I just wanted to notate that. Survey LA does not flag for associations with historic personages. So it wouldn't have been flagged for its association with Rudolph Ising. And again, this process is meant to preserve the story of the city's culture. And so now that we have this information about Rudolph Ising, which was not, all of that information was not actually made available to the Office of Historic Resources when the application was submitted, but it was to the Cultural Heritage Commission. Please support this.
Deborah Leffman. I'd like to read the Animation Guild's letter of support to the record. The Animation Guild is a strong support of designation of the Iden Reese Apartments Rudolph Ising residence as a Los Angeles Historic Cultural Monument. Rudolph Ising was a treasured pioneer of the animation industry. Many of the studios that he was instrumental in creating are signatory to our guild and still to this day are members. Rudy was one of Walt Disney's first employees and was part of the creative nucleus that led to Disney's early success. He was the founder of both Warner Brothers and MGM Animation Studios. It was under Rudy Ising's leadership that William Hanna and Joseph Barbera first teamed up, a pairing that ultimately led to the founding of Hanna-Barbera Productions. In recognition, Rudy was honored with a Lifetime Achievement Award from the International Animated Film Society. Rudolph Ising's legacy is of such importance that making this residence a historic monument is not only appropriate but necessary. It is a vital future to the future generations that realize that the history of film and animation is all around us. Thank you.
Thank you. Nicole Moran, Brett Johnson, Ryan Welch.
Dear council members, my name is Nicole Moran, and I oppose to this historic monument request for Kings Road. This project has no historic merit. The building has no architectural or structural importance or significance. In fact, it is a rundown building that exceeded its useful life. There are literally hundreds of buildings that are better examples of this style. This building is not a historic zone. This typical streamlined modern style is already preserved by other historic monuments that are much finer examples in historic zones. Our city is in a crisis for home shortages. We need to approve this and take advantage of the opportunity to create more homes. Thank you.
Welcome.
My name is Brett Johnson, and I must urge that you reject this nomination. It's a terrible precedence to set. We live in Los Angeles. Every year there's the Academy Awards. Every year 24 people win. They all have 4 or 5 houses. If we do that for every single person in 15, 20 years, there's going to be no place left to live. Again, I think it's critical to look at how long do you live here and what other historical things does he have. This isn't the most impressive building. This isn't what he was known for, and I think it's very important that we reject.
Ryan Welch.
Yes, good
Chelsea
afternoon.
Byers, Michael Nelson.
Good afternoon. Thank you. Yes, Ryan Welch. I live 1.3 miles from this location. I've driven by it quite often. I think the decision of the last body to go against the staff's recommendation was a little bit crazy, really opens up a slippery slope, as folks have been saying, and as I think that members of this body have recognized in their comments earlier. We all live lots of places. I've never lived any place that I think would be, significant for historic nomination. I believe most people believe that too, no matter how self-important they are. I would assume that, that this gentleman wouldn't have thought that the place that he lived in was worthy of being deemed historic. So I would just like to enter that as a thought. So thank you very much, and please decline this.
Hi, my name is Chelsea Byers. I'm vehemently opposed to the historical nomination of this project. I hear the argument that Mr. Ising's racist work was born in a different time and in a different context, and still a decision to revere it and to invest public resources into its protection is a decision that you will all make today. Mr. Ising's contributions to animation are vast and definitely include some material so insensitive and so offensive that is deemed too bad for publication and distribution. Historic cultural monuments are meant to foster civic pride in neighborhoods, and I question what pride is truly found in this racist legacy. So knowing what you know, what do you want history to remember as far as the decision that's made in this room today? Thank you.
Thank you.
Hi, my name is Michael Nelson. I'm opposed to this project, and I just want to point out that there are nearly 60,000 Angelenos with the experience homelessness every night. Around 200,000 Angelenos will experience homelessness in any given year. And I think this project is not even worthy even calling him a historical modern, or even making it, for the simple fact that he animated really racist things to kids, and they were truly living. Thank you.
Thank you. Dan Collins, Sidney Perry, Ronnie.
Hello, my name is Ronnie Abarca, and I'm here to oppose to people representing Mr. Ising, and I think it's evident to us all that the city of Los Angeles needs housing, and that's all I have to say. Thank you for your time.
Thank you.
Hello, my name is Sidney Perry, and I'm here today actually to oppose this as well. Without a doubt, we all know that Mr. Ising was a great animator, but on the way home from here, I will drive down Temple to Alvarado. I don't know if any of you guys know that route, and I'm sure if you have taken it, you've seen the homeless situation, how out of proportion and it is here. So today I'm here to oppose that. I think we need more housing. It would be great to have 6 additional units as opposed to just the 3, and that's where I stand. Thank you.
Thank you. Dan Collins, Jessica Munger, Arnold Justice.
Hi, Dan Collins. We're in a housing crisis, and this is just a clear attempt to halt development. The property on Kings Road has failed to meet standards for preservation already once. It's a building that doesn't need to be saved, and it shouldn't be saved because of Rudolph Ising. I appreciate that we call him Rudy in an attempt to make him seem like a good guy. He's part of the censored 11, and he was actually, what that is there's 11 cartoons that are so bad and so racist that if you take those parts out, they will cease to exist. They just won't be played because you can't. He actually directed the one called Hitting the Trail for the Hallelujah Land in 1931, so he is the first person to make that censored 11 list in 1931, essentially writing the playbook on racist cartoons. So I oppose this, and thank you for your time.
Thank you.
Good afternoon. My name is Arnold Justice. I'm here to oppose this project. I think that the city needs more housing. Although the people that live at the property have housing, they won't be made homeless. They may be displaced and placed someplace else, but they will be provided with homes. What we need is homes for people that have no home. Thank you.
Thank you.
Good afternoon, Jessica Munger. I'm going to go out on a limb here and assume we've all been reading the news for the last year, and if that's the case, we know that we, the people, are really fed up with honoring racist memorials. What we don't need to do is build more of them in Los Angeles from some obscure cartoonist. No one cares at all about who co-founded Looney Tunes, but we do care about is holding up the legacy of racism in this city. This is what you're choosing today to memorialize if you decide to go with Ponytail Steve's legacy here that he's trying to preserve about this racist cartoonist. Thank you so much in advance for having the decency not to continue this really bad trend that we see on a national level. Thank you.
Daniel Afari, Kyle Lips, Ali Kingsley.
Good morning, or good afternoon, council members. I oppose this nomination. I'm a SoCal native. When my husband and I were in search of an apartment for our growing family in West Hollywood, there was very little available. We were in search of an apartment that was clean, safe, had no signs of dilapidation, and this was a struggle due to the abundance of so-called historic apartment buildings, which were really just older, unsafe, and dilapidated buildings. We were lucky to get into a new building in the area before it was 100% leased. This new apartment provides safe, secure homes with secure underground parking, which deters muggings and auto thefts, an issue in our neighborhood. Our building has become a community for young families and professionals, which includes low-income tenants as well. We're grateful to have a healthy, safe, and well-maintained home. I hope this can be something that's more available to others who are seeking the same. Thank you.
Thank you.
Thank you, council members. I'm opposed to the nomination. It should be noted that the applicant's original application did not include icing. It was only after that the staff report had recommended not nominating this historic application that they went to find someone to make it historic. The Cultural Heritage Commission oversees the designation and protection of local landmarks. Disregarding the staff report and designating this building as historic for an applicant that is clearly an anti-development activist with the sole intention of stopping construction is wrong. It dilutes this commission's authority and offends the designated cultural monuments that this commission is charged with protecting. We should protect and honor our monuments that enshrine our history. This building is not a historic monument. By allowing these anti-development activists to name this historic to stop construction is not justice. Thank you.
Thank you. Arlen Allen, Dante Davis.
Good afternoon, council members. My name is Kyle, and I oppose any designation of historic monument for the King's property. I am born and raised in Los Angeles. My children are fourth-generation Angelinos. I work in the area and drive by this building weekly. The building is in no way, shape, or form a historic landmark. We have beautiful buildings in this city that have been designated historic monuments. This building has none of the characteristics or historic sense of charm these other buildings designate carry. Our housing in this city is in a detrimental state. We need development and more available units on the market in order to cater to the demand our city requires. Lastly, and most important, economic development relies on expansion and change our city and neighborhoods desperately need. Thank you for your time.
Good afternoon, council members. It's very disturbing to me that we're even wasting our time here talking about a known racist. This location has no historic monument to this community and is being driven by an anti-development activist group. We all need to realize how important this development is for the city in such a crisis for housing. Rudolph Ising is a known racist, period, which is offensive to my culture. I do remember watching his cartoons as a kid, and in retrospect, cannot believe this was acceptable then and still acceptable now in discussion. I oppose any designation as an historic monument. Thank you for your time.
Thank you. Dante Davis, Deborah, so now Harlan Allen and Deborah Spinelli, Roy Oldenkamp. Welcome.
Harlan Allen. I oppose this vehemently. Yeah, when we were kids, we used to watch this as an example of stuff that we thought would never happen. The absurdity of this actual, the Alleluia. I don't know if you guys took a look at it. It's absolutely terrible, and it's shameful that we're taking a look at this again. It's offensive for me to even think about that we're going to actually try to make a monument of some sort to an individual like this. Yeah, there's a lot of people who won Academy Awards that probably are terrible individuals. We're discovering a lot of them. Why is this person not included in that? Why is this person somehow okay, considering the political environment we're in right now? Just sort of quickly, everybody's looking at Los Angeles for a whole lot of reasons as an example. Is this the example? Is this the racist, bigoted individual that you guys want to honor? Take a look. Thanks a bundle. Bye.
Thank you. Deborah Spinelli, Roy Oldenkamp, Mark Walcott, Hector Barbosa. Welcome.
Hi. I'm here in support of the designation of this, and I'd like to stress that there is a housing crisis, but it's an affordable housing crisis. So it doesn't really make sense to me to take away affordable units and build things that are not affordable for anyone in the community. Thank you.
Thank you.
Good afternoon. Roy Oldenkamp, City of West Hollywood, President of the West Hollywood Preservation Alliance. The Alliance concurs with the Cultural Heritage Commission findings. We ask that you listen to your experts. They're the ones who know best. Rudolph Ising is indeed of a different time and an important pop cultural personage, and his residency on Kings Road was in his creative peak. That should be a paramount consideration. With parting Rudolph Ising words, that's all, folks.
Thank you.
Mark Walcott, I support the designation of this structure as a historical cultural monument for the sake of the current residents. And the Hollywood Studio Club at Lexington and Lodi, just west of Gower, where Farrah Fawcett stayed when she first moved to LA, less than 3 years, just for a few minutes. I can still point that out to you. The building where Marilyn Monroe and Charlotte Winters were roommates on Hollywood Boulevard when they first moved to LA, staying much less than 3 years. I can point that out to you as well. The structure should stay intact, at least because it would show that the City Council is sensitive to maintaining the city with the character, with the characteristic that certain places can be pointed out for their significance, for their historical significance.
Thank you. Hector Barbosa, D.N. Newkirk, Louis de Armand, and Austin Sear.
First of all, I want to say that I don't think that is the best idea to pass, landmark status as if it was candy. I had a cleaning service that served between Malibu and Echo Park, and in all that time, I've worked in so many homes that a lot of celebrities, politicians, and people in all around the entertainment, industry worked over the last few decades or lived. And at one point in the future, we're going to be here trying to declare, landmark status on any of these buildings from some people who are probably more deserving, than this Rudolph Ising. Another thing is that my friend who lives only a couple of blocks down the street, he's been interviewing after 5 people every single night for the last 2 weeks because they're trying to rent a room from him. And they just can't find enough, either affordable or any kind of housing right now in the area. So we must take that into consideration. And if you ask anybody who's ever had a hard time finding a place, would they really vote for this project?
Thank you.
Good afternoon. Lois DeArmond.
I'm here today to urge you to grant HCM status to the Adlin Reese Apartments Rudolph Eisling residents. I lived a few blocks from this building for 28 years. I love the old historic neighborhoods, and I hope we can preserve them. I'm also a proud member of IATSE Local 839, the Animation Guild. Entertainment-related arts helped build this city. I'm sorry, I'm reading. Animation was and is an important component of the entertainment industry. We need to preserve this building, which initially housed an important early Hollywood animator who has 6 Academy Award nominations. Also, $4,000 apartments are not going to be housing the homeless. Thank you.
I'd like to take 2 minutes. I'm speaking for myself and for my daughter.
You have 1 minute, ma'am.
Hello, my name is Emma Rose Sunmacher, and I am 2 years old. In 90 days, my mommy and daddy are going to lose their affordable housing of 13 years, and I am going to be evicted, making me over 300 people in this city who is evicted by Weissman Residential. This Plum Committee, you usually use your power to support the HCMs, and if you don't now, it's going to look very suspicious. I want to talk to you about 3 letters. A, which means architecture, artist, you can come with me, and the letter D, developer, demolisher, devastation, and the worst word of all, displacement. Now I want to talk to you about, my mommy says that for every 1 RSO unit that gets demolished off the market, it costs the city $421,000 to replace that 1 unit. I only can count to 10, but my mommy can count higher, and she says that's $1,263,000. I don't know and understand math, but that sounds like a lot of 10s to me. I also love the favorite subject of cartoons. I think it's pretty neat that the Historic Cultural Monument honored, and hopefully so will you, the artistry.
Thank you very much. Your time is up. Thank you. Thank you very much.
And if you're against this,
thank
it
you
doesn't
very
look
much.
good on
Your
this
time is
commission.
up. Thank you. Sometimes the best way to get your point across is to listen as well. Thank you.
Thank you very much, and I will not use my list of already written up expressions because we've heard a lot of these ones already today. We've also heard a lot of things that don't actually apply to this nomination. The type of units that will be built, the type of units the city of Los Angeles should see built. That's a conversation at a different point in time, and one as a housing activist I'm excited to have. This conversation, though, is about the historical merits of the building and the subject in question. The subject in question has been either he's a racist or his work is racist, and that's not me talking, that's the people who are in charge of syndicating his material. We have an opportunity to preserve 4 other of his properties that does not seem to be of importance or care at all in this. If the nature of this conversation was to sincerely preserve the man's history and legacy and work, we have 4 other homes we could do that with currently that are not as much of a controversial position as this. We also have the opportunity to build a Bugs Bunny statue, or we could name a cafeteria at Warner Brothers Studios after the man. Please don't trade my future for someone else's past. Thank you.
Okay, that concludes the public comment for today. Are there any other questions or comments from committee members?
No, I just
Harris Dawson.
thank you, Mr. Chair and staff that commented on this today. It was very fascinating to listen to the testimony this afternoon. It seems to me, and I would just offer this as an editorial comment, it seems to me that there are lots of folks who want to preserve the character of neighborhoods, folks who want to stop new developments, folks who want to preserve the past rather than move forward. And all of those things, I think, are fine and things that we can have debates about. But when you step in front of a committee and ask members of a committee to take a vote to enshrine the legacy of someone who produced as vile a content as this person did, it's difficult to frankly hear anything else you're saying. To stand there and ask me to affirm this person's legacy and affirm their work when you could have easily asked for historic preservation for his wife, who was a well-known actress. I mean, just the thoughtlessness of that leaves me quite shaken this afternoon. And so I just want to offer that to everybody who brings, and lots of you I've seen lots of times, who bring on a regular basis preservation nominations. Give some thought to the individual that you are trying to enshrine, and the work and the contribution and what they left on earth with us.
Thank you. Any other questions or comments? Mr. Price?
I just want to say ditto. I just want to say ditto, Mr. President. Thank you. Thank you, Mr. Marquis.
Thank you very much. Mr. Blumenfield?
Yeah, just wanted to add one thing. You already know where I stand on this, but just to be clear, even if we were to approve this historic nomination, that doesn't prevent this building from being taken down and the units from being replaced. Maybe it slows that process down a little bit, but that's not what's before us. What's before us is this historic preservation issue. Either way, this building isn't saved by our actions. So I just wanted to put that forward.
Thank you. And before we take the vote, I also like to comment that what's not before us is a project that's being proposed there. What's before us is just a nomination. And this committee has certainly taken strong stand against the displacement of RSO units on the merits. There's been a miscommunication between the housing department and the planning department when it comes to approving new projects where RSO units are at that location. And I've seen a strong interest from this council to protect RSO units. So we certainly are concerned about that. However, what's before us today is a nomination, and I'm concerned that what the commission did in respect to nominating this, it's a very low standard as to what we will nominate in the city of Los Angeles. And if we proceed on those grounds alone, where it will be taken as a serious consideration for those that are nominated, we would set a very low standard. I consider myself a preservationist. I've urged and got several historic preservation overlay zones in Council District 14 and have promulgated a number of policies to strengthen our preservation laws. But this doesn't reach the level of nomination. In addition to that, the timing of this can be much worse. We have a national debate on what other public contribution statutes, et cetera, exist, and that discussion continues. We have a president that has been shown to be racist, and this can be given to us at a worse time when that discussion is going on throughout the country. That's my opinions on this. So with that, any other questions or comments? So we'll move to overturn I'll make a motion that we move to overturn the Cultural Heritage Commission recommendation and deny the inclusion of the Adeline Reese apartments in the list of historic cultural monuments. Second by Mr. Englander. Any objections?
Councilman,
yes, sir.
You may wish to adopt the underlying findings of the Planning Department.
And we will adopt the underlying findings of the Planning Department and as originally stated
to not declare it.
To not nominate. Okay. Any objections? See no objections, so ordered. Thank you. Next item.
Next item. Next item, Councilman, is an appeal filed by Save Old Hollywood. Jamie Hall is the representative. This is a vesting tract map for 18 small lot homes in CD4.
Okay. Staff, can you present on this item, please?
Hi, good afternoon. Jordan Turner, Department of City Planning staff. As mentioned before, using a second level appeal of a vesting tenure tract map 74942 for the development of 18 small lots. As part of that action, the advisory agency also approved zoning administrator adjustments for an increase of height from 30 feet to 33 feet 6 inches and allowing a reduced lot area of 1,200 square feet in lieu of the 1,500 square feet required in the RD 1.5 zone. There are 4 main appeal points that were submitted originally by the appellant, and from my understanding, they also submitted, I think, additional points that I briefly read and I'll try to touch upon. Their main appeal points revolve around the CEQA, the Class 32 exemption that was used as the environmental clearance for the document. There's a detailed response prepared by the department dated January 19th that kind of goes into more detail about each point, so I'll just sort of highlight the points that are raised. As mentioned, the appellant states that the project does not qualify for a Class 32 exemption. The project site is located within an urbanized area. It is zoned and planned for residential uses. Also, they mentioned that street tree removals require discretionary permit from the Board of Public Works, which triggers environmental review under CEQA. The Department of City Planning, and specifically the advisory agency, was the lead agency in adopting the categorical exemption for the document, and the Board of Public Works under CEQA is a responsible agency. Hence, there is no additional environmental review that is required by the Board of Public Works, as they are a responsible agency, and hence there's no attempt to piecemeal any part of the project. The appellant also states that the project is not exempt from CEQA because the city has proposed mitigation measures in the form of specialized conditions. Well, as a categorical exemption, there are no mitigation measures attached to the project. What the appellant is mentioning are the standard conditions of approval that are attached to all subdivisions. Lastly, the last point revolves around incompatibility with the existing community. As I mentioned, the site is planned and zoned for residential uses and currently contains residential uses. As sort of discussed in the earlier small discussion, this particular site and street is comprised of single-family and duplexes that are about 1 and 2 stories in height, and the proposed small lots will be 3 stories in height. However, they are allowed by the zoning, and hence are compatible with the zoning and land use category for the site. So in conclusion, the department recommends that the Plumbing Committee deny the appeal and sustain the decision of the Central Area Planning Commission approving the decision of the Deputy Advisory Agency. Thank you.
Thank you very much. Okay, so the appellant, Representative Jamie Hall for Save Old Hollywood.
Good afternoon. Jamie Hall with Channel Law Group. I'm a planning and land use attorney on behalf of Appellant Save Old Hollywood. I want to start first with the Class 32 Urban Infill Exemption. It's important to recognize the criteria that you have to adhere to in order to be eligible for this exemption. And one of the criteria is the project has to be consistent with all applicable zoning regulations. That's the very first one. And yet, we have an applicant here who is seeking to deviate from the zoning regulations. He's seeking to get a variance, essentially. You want to call it a zoning administrator's adjustment, but it's really a variance, to have an overheight building. The height limit is normally 30 feet. He's seeking to go to 33. He wants a reduction in the minimum lot area density of 1,200 square feet instead of 1,500 square feet. And he wants to permit 18 units instead of 17 units. So how can you be eligible for a Class 32 exemption when you're seeking to deviate from the applicable zoning regulations? That's just a logical fallacy and it's circular reasoning. And this, therefore, Class 32 exemption does not apply. I also want to note that this project is actually seeking a variance, not a zoning administrator's adjustment. And the city's actually already been sued on this issue, and the Los Angeles County Superior Court judge actually invalidated the city's action. Robert O'Brien specifically said that the city charter section 562, which relates to the required findings for a variance, the city cannot supersede the city charter by doing zoning administrator's adjustments. So again, the city lost that case, and it's currently on appeal before the 2nd District Court of Appeal. You're doing the exact same thing here, and I'm alerting you to that fact. The required findings for a variance have not been made. Also, I want to note that the findings regarding the site characteristics or the existing improvements are inadequate, and that the findings fail to address that the fact that the proposed project is located in a block that largely consists of single-story buildings. On Lexington, they're all single-family residences. The findings fail to address the fact that the proposed project will further degrade neighborhoods by converting them from low-scale, interesting architecture to multi-story, undistinguished architecture. Some other things to talk about here. The findings do not provide any kind of detailed analysis of the conformance with the general plan or the community plan, and only cites 2 community plan objectives and 1 housing element policy. Another thing I want to indicate here is that the project requires a historic resource assessment. All but 1 parcel on the block contains at least 1 structure that was constructed between 1912 and 1940, and no buildings on the block are less than 65 years old. While this property was not identified, these properties were not identified on Survey LA, that does not mean that they're not potentially historic. And this is stated directly from Survey LA. All surveys were completed from the public right-of-way, from vehicles or on foot. Survey LA was not exhaustive. It was more of a windshield survey. As a result, the survey misses many resources which were associated with particular individuals. And that's the situation here. And Survey LA actually describes the uniqueness of these single-family residences that were built in close proximity to the motion picture industry. Given that the age of the buildings, an historic resource assessment should be conducted prior to ruling these buildings out as historic resources. The age of the buildings on the site is an unusual circumstance with the potential to result in significant impacts. I also want to indicate here that the project may have an impact on noise, and there should be some sort of analysis with regard to noise impacts, because the noise ordinance actually has an out. There's what's called a technical infeasibility provision in the new noise ordinance that gives developers a free pass. This language, coupled with the proximity to other residential developments, presents an unusual circumstance with the potential to result in significant impacts unless a proper noise impact assessment is conducted. And finally, even though I wasn't aware of this, today you passed and put forward to the City Council some new regulations related to small lot subdivisions that would sort of ease the impacts associated with these projects on the adjacent single-family neighbors, increase setbacks, etc. Well, why isn't this project being subject to that? You have the discretion here to tell planning to go back and look at the same conditions of approval. Thank you.
Thank you. Jeff Thomas, the representatives are Sami Koham Neem and Kevin McDonald. Oh, Kevin McDonald.
Good afternoon, Chair Weezar. My name is Kevin McDonald of the law firm Jeffer, Mangles, Butler, and Mitchell. Good afternoon, members of the Plum Committee. Represent the applicant and owner of the property, Jeff Thomas, who is here today. The land use professionals that you mentioned are here as well, who shepherded this through the initial process. I think staff pronounced the entitlements correctly. What's before you is merely a small lot subdivision with a 20% adjustment for yards and a 3-foot 6-inch adjustment for height. The adjustment for height is merely to allow for clear plexiglass guardrails at the rooftop decks. And the adjustment is only necessary for the yard or the lot area because we happen to be in the subdivision context. Had this exact same type of multi-unit project been done outside the subdivision context, you would not need the adjustment for the yard area. So I would like to let you know, though, the project before I got involved that was shepherded through by the land use development consultants that are here today went through extensive public outreach. Julia Duncan, a planning deputy for Councilman Ryu, hosted several in-office meetings with my clients, with neighbors in the area, and there was an agreement to incorporate certain amenities into the project at the request of the neighborhood, and that was done. Those were incorporated in the actual plans that were approved by the Deputy Advisory Agency. It was only until the neighborhood council meeting that followed that we learned that the neighbors, despite getting the concessions that they wanted, vowed to oppose the project in any event. I would like to address some of the comments made by Mr. Hall, but before I do that, I need to put on the record that there are a number of procedural problems here, and all having to do with timing. The subdivision rules require that an appeal be filed after the advisory agency's decision within 10 days, which was done. The rules also require that there be a hearing before the Area Planning Commission within 30 days. This hearing was conducted 38 days after the filing of the appeal, and therefore was deemed denied on that 31st day. The rules also require that there be an appeal filed to the City Council within 10 days of the decision under the initial appeal. This was not filed until 25 days after the deemed denied date. So none of these things should be before you as a technical matter, but purely on the merits, the appeals that have been filed have absolutely no legal merit to them at all. The letter that was filed with the Area Planning Commission essentially just repeated tenets of sequel law without applying them to the situation in the slightest. That exact same letter was filed on January 8th as an appeal of the Area Planning Commission determination merely by changing the date on that same letter. After 9 o'clock in the evening last night, I noticed delivered to my email was a couple of supplemental letters that Mr. Hall had apparently submitted to the city clerk's office at that hour as well. But to the merits, the categorical exemption is appropriate. Mr. Hall's characterization of the inconsistency with the zoning merely because adjustments that are provided for in the code have been applied for, he misstates that requirement under Class 32. The requirement is that there be general consistency with the general plan, which is a mandatory finding, by the way, that goes along with the adjustments that were granted. And that finding has been made. Mr. Hall points to a superior court case in LA that is now pending under the Second Court of Appeal. That law is not controlling. It's merely one isolated court decision. What you are bound to do is enforce the municipal code as it stands before you today. Mr. Hall also made some comments about site compatibility, etc. Well, he fails to mention that on the same block where this particular property is, there are several multi-story, multi-unit buildings, many far taller and larger than we are proposing here. There is no historic assessment. There's no historic value in this property. That matter is simply not before you. In terms of the other supposed impacts that Mr. Hall mentions, he's obligated as the appellant to bring before you substantial evidence to prove that there are, in fact, impacts associated with this, that there are problems with the findings that were made by the previous decision makers and appellate body at the Area Planning Commission. He has failed to do that both in his written submissions and here before you today. With that, I'm available to take questions.
Thank you.
Thank you.
Our next speakers are Julia Duncan from Council District 4, and then DJ Cote. Welcome. Yeah, want to go first?
Julia Duncan, Councilmember David Rue's office. Our office has been actively involved in this project for several months and hosted several meetings at our Hollywood office following the initial hearing in August of 2017 between the project applicant and the neighborhood group. At that time, it became very clear that the neighborhood had concerns about changes in their community. This particular lot is zone RD 1.51XL and is in a broader multifamily zone that has been developed with older single-story multifamily housing, as well as projects ranging between 3 to 5 stories. Just to correct a previous statement, a project to the immediate rear of the property to the southeast is 5 stories. The items of concern that were brought up during the meetings our office hosted with the project applicant and the neighbors included outright opposition to the project, parking. One of the biggest concerns was the width of the street. The BOE dedication and roadway improvement actually helps alleviate the parking concerns in the community. Height, density, landscape plan, and green wall. Construction timeline, staging plan, and balconies. Based on this input, the applicant provided a staging plan, a landscape plan, a construction timeline, in addition to a potential architectural revision to a Spanish Revival style that seemed more consistent with the neighborhood, but was subsequently rejected by the involved neighbors. Architectural revisions were not of particular interest to the community. This project qualifies for a categorical exemption, Class 32, and meets the 5, for an infill development, and meets the 5 conditions to qualify. We worked really hard on this, but we respectfully request you deny the appeal. Thank you very much. If you have any questions, I'm available.
Thank you. Last speaker is DJ Cote.
Good afternoon, council members. I'm DJ Kuti. I reside on the same block as this proposed project. I've been there for nearly 15 years, and it is a block of all single-story homes, some of them with some cottage or mother-in-law apartments in the back. I'm also the president of Save Old Hollywood, and I do have to say for the record, I have not had any contact or met with any of these people to discuss this despite us trying to do so. We've been denied access, and so these concessions are unfamiliar to me. I'm here on behalf of myself and all my neighbors who signed that petition that we presented to the planning department with our opposition, and I also presented that opposition to you. It's quite lengthy. I'm not going to go into it here, and it's regarding all the negative impacts that this small luxury project is going to have on our single-story historic block. So I ask you to oppose the project, or at least halt it until we can come up with a better one, and I ask you to please stop the destruction in Old Hollywood. Thank you.
Thank you. Any other questions or comments? No? I'll move that based upon the testimony and testimony by Council District 4 that and the staff was recommending the denial of the appeal. Any objections? Seeing none, so ordered. Thank you. Next item on the agenda.
There are no further items.
No public comment. I believe that concludes this meeting. Meeting adjourned. Thank you.